Hey, welcome back. This is Module 8B for Estate and Gift Tax. We're talking about powers of appointment. In the first half of this video, we talked about some terminology and the general concept of a power of appointment. We looked at Section 2041, and now we're ready to move on and look at a couple of the cases from your casebook. First one I want to talk about is Keeter versus United States. It's on page 367 of the third edition, 383 of the second edition. Okay, so what happened? Daniel Shaw died owning life insurance on himself of $100,000. Okay, little sidebar. Hang on. He owned life insurance on himself? Mistake. The insured should not own the life insurance. Okay, this was long enough ago that maybe that wasn't an issue, but now we've already seen that when we own life insurance on our own selves, that means the proceeds are included in the estate. But we're not actually talking about Daniel's estate, so who cares? Here's what he did. The option that he chose left the proceeds kind of in a trust with the insurance company to pay income to his wife for her life, and then everything to wife's estate when she died. Okay, Mrs. Shaw is the estate we're really interested in. Mrs. Shaw died and she left a will. And her will said, this is the residuary clause, all the rest, residue, and remainder of my property of every kind and description and wherever located, and any property over which I may hold the power of appointment or distribution, I give, devise, and bequeath in 3 equal portions. That was for her 3 daughters. So basically, the insurance company pays to her estate, and her will says what to do with the money. Okay, what do we know for sure? If Mrs. Shaw had a general power of appointment, then her residuary clause did exercise it. We don't have a question about that. And if Mrs. Shaw had a general power of appointment, it was created before October 21st, 1942. So that means now we just have to decide whether she had a general power of appointment just because the insurance money was payable to her estate. Because remember that for a general power of appointment created before 1942, exercising the power in a will means that we bring the property into the gross estate. So, what's the right answer? The insurance company paid $25,000 to Mrs. Shaw's estate. Her will told her executor how to dispose of all the property in her estate. So doesn't it seem like the $25,000 ought to be included in her estate for tax purposes? It seems like it should, since she actually got to say what to do with it. But on the other hand, think about this. She did not own the property at death. She had not made a transfer of the property and held on to the right to make changes. It was not joint property, and she did not make any changes within 3 years of her death. She also didn't get to enjoy the property herself. So nothing that we've seen so far would include that $25,000 unless we now decide that she had a general power of appointment. And in that case, then 2041 will bring that into her estate. So the court focuses on the right to say where the funds are going. A grant of distributory suzerainty over a fund is a general power of appointment, regardless of the source of the fund. Wow, distributory suzerainty. There's a phrase for your next cocktail party. Further, granting the insurance funds to the executor was about the same as granting it to her to appoint by will. Do you agree with that? Right? This is the funds go directly to the executor, but her will is going to tell the executor what to do with the estate. So tax result, court says yes, we do include the funds in Mrs. Shaw's gross estate under Section 2041. Okay, let's move on. Jenkins versus United States. This one makes me kind of sad. Ada Lee Jenkins and Martha O. Jenkins were sisters who lived together. Now, you may not know this about me, but my sisters are identical twins, and they live 2 blocks apart. Ada Lee and Martha weren't twins, but they lived together for a long time. And then look what happened. September 24th, 1962, Ada Lee died. October 4th, Martha renounced her nomination as the executrix of Ada Lee's will. And then 1 week later, on October 11th, Martha died. Now, Ada Lee, she's the first one to go. Ada's will left property to her sister Martha with this language: to have, hold, use, and enjoy for and during her natural life, with full and unlimited power and authority, to dispose of the same in fee simple, by gift or otherwise, at any time during her life, without accountability to anyone. Okay, now the opening language, the red part, kind of looks like a life estate for and during her natural life. But the purple part looks like a right to use up the property. Looks like a general power of appointment because it says she can give it away. And it looks like a general power of appointment that could only be exercised during her life. Okay, but keep in mind, we're talking about a post-1942 power now because this Ada Lee, actually both of them died in 1962. The problem, why do we care? Ada Lee's property was included in Ada Lee's estate. If she gave Martha a general power of appointment, then all of the property is included in her estate as well. And they died only 17 days apart. The idea is supposed to be tax things once each generation. 17 days hardly seems like a generation. So we need an argument. What we have to argue in order to keep this out of Martha's estate is that all she got was a life estate and she did not get a general power of appointment. Okay, if we can't make those arguments, we're kind of stuck. Okay, so what argument is there that there's not a general power of appointment? Well, the power could only be exercised inter vivos and not by will. Does that help? Well, no. 2041b1 says a general power of appointment is one which is exercisable in favor of decedent, estate, creditors, or creditors of the state. We only need one of those. So if she could exercise that power for herself or for her creditors, that's enough. Okay, the power was subject to an ascertainable standard, right? We know that means in general that we don't have any discretion, kind of like not having a power. Huh? Where does this one come from? Well, the argument seems to have been that Martha was known to be frugal, and she would only have used the power to provide for her real needs for support, maintenance, and so on. You know, I watched Extreme Cheapskates or something like that on TV last night as I was falling asleep in front of the TV. Maybe we're saying that she was one of those people. Well, likelihood doesn't matter, and we've seen that before, right? We didn't care if those crummy kids were likely to exercise their powers. Likelihood doesn't matter. It's what you're empowered to do. It's the legal rights that make this a general power of appointment. Third, Martha didn't have an exercisable power because Ada Lee's will had not yet been probated. I didn't fill in the response here. Do you have any idea? Well, if you go back to that little timeline, she did manage to get in there and say she didn't want to be executor. All right? So clearly she was aware and she was able to exercise her right to have legal action. So the fact that the will hasn't been exercised, hasn't been probated, doesn't make any difference. She knew she had this power. She could have exercised it. Fourth, she didn't have a chance to disclaim or renounce her power. Well, we know that she did. She certainly knew about it because her will was the same, and she did find time to renounce the executorship. So obviously she was paying attention. So the court finds, yeah, she did have the opportunity to renounce the power. Okay, so wait a minute, let's go back. So what's our result? We include all of Ada Lee's property in Ada Lee's estate and also in Martha's estate. because of the general power of appointment. Okay, they could have done a little bit better with their estate planning, I think. Okay, so the next thing for you to do is go to the discussion board and post your opinion. Should it matter whether the donee of the power knows about the power? And if you think it does, how would we know whether they know or not? Okay, look for the next modules a little bit later, and we will start with the problems on page 375. And I'm sorry I don't have the page number for the second edition. Thank you for watching.